The Justice Department is opening an investigation into disability and religious liberty discrimination. Sounds serious, but at its heart, it's simple, making sure everyone gets a fair shake. What sparked it and what could change? Stick around to hear what our panelists have to say on this topic. Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or your politics starting to shape your faith. In other words, what do you do when God and government come face to face? I'm your host, Orland Johnson. Let me introduce you to our guest panelists for today. First, we have with us Judith Hawkins, former judge and attorney in Tallahassee, Florida. We also have with us Dr. Andrew Polk, associate professor of history at Middle Tennessee State University and the author of the critically acclaimed book, Faith and Freedom, Propaganda, Presidential Politics, and the Making of an American Religion. We also have with us Ms. Melissa Reid, who's the director of government affairs for the North American Division of the Seventh-day Adventist Church. And we have with us Dr. Nia Johnson, who's an assistant professor at Wake Forest Law School. Great having you guys here with us and looking forward to our show for today. You know, recently the Justice Department opened an investigation into disability and religious liberty discrimination. The Justice Department Civil Rights Division has launched this investigation into the city of Rainsville, Alabama, to determine whether the city violated Title II of the Americans with Disabilities Act, the Religious Land Use and Institutionalized Persons Act of 2000, and the Fair Housing Act by denying a faith-based organization's application to operate an addiction recovery facility in the city. The department opened this investigation after receiving a complaint alleging that the city denied a Christian recovery organization the ability to establish a Christian discipleship program motivated by a desire to keep away drug addicts. You know, Judge Hawkins, when you take a look at some of the things that's going on, whether from a statutory standpoint or just local politics, and you see that we've got these type of what I would call maneuvering that's taking place between one side of a society and the other side of a society, what I'm trying to figure out with this particular launch of an investigation by the Justice Department, how do we find the right balance? And the bigger question is, what exactly are they looking for?
I don't know, but by now you know facts matter, and I need to know the facts before I can get started. So let me just give you all some background here. Rainsville has a population of about 5,000 people, and it's located about an hour away from Huntsville, Alabama, and Chattanooga, Tennessee. And Gregory, who is the executive director of Total Recovery Ministries, and his co-director, purchased this 12-bedroom, 12-bath property for the purpose of turning it into a halfway house for recovering men recovering from addiction. They themselves are recovering from addiction. Now, I got a procedural question because apparently if the zoning commission rules against you, you're supposed to take it to the circuit court. I couldn't find any indication that the case had gone to the circuit court. However, at the zoning meeting, there were a lot of people there who took both sides. But the folks who were against it raised issues that this was a commercial property and they were concerned about the purpose of the property's use next to their property, better known as, I'm not opposing to the program, but I don't want it in my neighborhood. And one of the owners commented that the building is located just about 10 feet from the property line. Someone else very gratuitously talked about how, I've got 4 children in this neighborhood and I just don't want them close to those kinds of people. And what about the children and the elderly? But what's really fascinating that I would really like to know is if this is a 12-bedroom, 12-bath property that they purchased, what was it used for before? So we can now go into all the legal arguments, but somebody needs to answer those facts because a 12-bedroom, 12-bath house had to have housed more than one family, I would assume. I'm going to make that assumption.
Yeah.
Therefore, whatever this commercial use is that they want to use it in terms for the recovery center should be in line with the zoning. So what's the difference?
Yeah, the difference there, I think, is the key here, right? This is the not in my backyard issue that comes up a lot, especially I think we've talked about several times on this program, usually referring to like homeless shelters in a neighborhood going in. Yeah, but the zoning questions here are difficult and multi-layered because it seems like the chief issue here is an ADA compliance issue, which gets muddy very quickly in these types of situations. Not that recovering alcoholics or addicts aren't covered under that, but applying those laws to local zoning issues gets messy very quickly. It seems to be one of these times that we have all the time where there is the practicality and fundamental issue of people on the ground, and then using the law, usually in big umbrella terms, to deal with something that is far more specific than those laws were generally intended to cover.
You know, Andrew, that's exactly where my mind went too, because my understanding, and you all are attorneys, so you can correct me if I'm wrong, but my understanding is religious organizations are primarily exempt from ADA requirements, right? And so I was surprised that that was a component of the lawsuit. And yeah, so exactly what you were thinking, I was thinking. It seems like they were maybe sort of throwing the book at them. As far as Judge Hawkins' comment about the circuit court, my reading is in May of 2025, the circuit court judge ruled in favor of the zoning board of the city of Rainsville. So I don't know if anything has happened since then, but it's interesting to me, you know, we've had these conversations, as Andrew alluded to previously, about, you know, RLUIPA cases or religious land use cases. And I very much have been a proponent of let's not discriminate against the religious organization. And I stand by those arguments. I think a big difference here is that they're asking for the area to be rezoned. You know, Judge Hawkins, rather than just denying, you know, a particular religious organization in a commercial space, in an existing commercial space. And to me, I'm a bit more sympathetic to the community surrounding it. It sounds like it's very much a residential community, you know, and it's understandable to me that they wouldn't want any sort of commercial property moving in there. So those are my thoughts.
Yeah. I also just want to, you know, jump in because I think another theme here is something we also talk about a lot on this show, which is when folks who are religiously minded or religious organizations are jumping in to solve for a social structural issue. And the reason that these religious organizations are here is because governmental institutions have essentially failed them. So for example, you know, we're in a moment right now where, you know, the current presidential administration has essentially designated certain medical professions as professions and others as non-professional for the purpose of not funding them for student loans. However, when you're not necessarily, you know, providing resources to train people who specialize in addiction recovery or specialize in like public health rather than policing and some of these other things, then it then becomes the church's challenges or religious institutions' challenges to try to solve for a social ill. And you can also imagine that in a town that is the size, you know, as Judge Hawkins so graciously said, of 5,000 people, right? There's a lot more intimacy in that space too. So you may have religious individuals who feel more comfortable taking on this role due to the informality that may be present. And then you have other folks who, you know, may be really well versed in some of the legal challenges in that space to try to utilize zoning requirements to kind of keep them, you know, from doing certain types of work. So it's a number of different competing interests. Like, I don't think it necessarily irons out from a policy standpoint to one or the other. But I think it's a number of converging forces that have kind of evolved into a broader conversation about, you know, how do, on one hand, religious organizations do the community work that they care about, right? Like, and how do they do it, you know, in a substantive way? On the flip side, you know, whether individuals potentially have a property interest in keeping a certain tenor around their property, right? And, you know, thinking about at what point does, like, you know, the goals of a church and institution interfere with the goals of individuals when it comes to where they live and what they get to do.
So let me go back and ask you, Melissa, the circuit court, what was the basis for their finding?
Oh, I don't know the answer to that.
Because
I mean, no. I know they ruled in favor of the city, but as far as the basis, I don't know the answer to that.
it sounds like the Mavenier's argument is carrying the day until we can verify it, that this is a very small community.
Yeah.
And that people are very concerned about maintaining the atmosphere, the tenor of their community.
Absolutely.
But it still begs the question, what did you do with a 12-bedroom, 12-bath property that is in this residential community?
I mean, it's possible, like, when we talk about these like larger pockets of the South, or rather smaller pockets of the larger South, it could have been a residential property, right? Like, like part of the reason you may move to an Alabama, you may move to a Tennessee is so you have the land to build 12 bedrooms if you want to. And I think there's also, again, a very different feel of, a 12-bedroom property being used for one purpose, whether that's residential and everybody's not living in the property, to then being a place that's essentially, what some are calling a halfway house. And again, this is, it comes back to, I think, something that many institutions are dealing with right now as we're having more of a national public health crisis when it comes to mental illness and addiction, et cetera. Where folks are like, yes, we want individuals who are struggling with addiction to become well. Do we want them to do it where we live? The answer is no, right? And so then the question becomes, well, then where do these individuals go, right? And how do we keep them out of harm's way?
I think, Orlin, this is a really good lesson for us as people of faith who want to be able to serve our communities in various ways, as Nia pointed out, in ways that they are not being effectively served already, right?
Yeah.
But it's a good lesson for us to do our due diligence before we move away with purchasing a property, right? We want to make sure that we're going in the best path forward. So, yeah, I think, unfortunately, good lesson for the rest of us, a frustration for the religious organization involved there.
Here's another little tidbit. The organization immediately went to the community. They even had news coverage saying that they had faith with no money, and someone plopped down $28,000, which covered the deposit for the property, and they helped to pay off the remaining maybe 60, give or take, thousand in 30 days or so. So that's strong support on one side for the offering into the community. So yeah, that's why I always like to know the backstory.
Well, Andrew, what's really interesting about all of this is something that a community thinks that it's important. We have the whole NIMBY, not in my backyard kind of concept happening. But the reality is that somehow this gets almost feeling like a bait and switch as it relates to a RLUIPA, where somebody buys it for a specific purpose, and the moment everybody realizes what the real purpose is, now all of a sudden they got some reasons why it doesn't work for you. And I think that's part of the big problem here.
Sometimes we talk about this like we talk about like public education versus a private Christian school. So a private Christian school is the same education, same purpose, right? But they add the religious element. That's not necessarily the case when we talk about religious nonprofits and religious social services. There's a lot more legally that goes into it. That again, part of that is due diligence on the side of the organization itself.
Sure.
Part of that is hopefully more communication with the entire community. So if this is something that the entire community wants and needs, that they can find a way to do that that's resolved beforehand.
I'm going to let that be the last word, Andrew, but I think you're right on point with that. Some of this has to do with, the social society that you're in that's looking to do something a little bit different. And sometimes it's people really trying to do a bait and switch. I'm not sure if that was the case here, but it's so important to realize that once you begin a process and put investments in that process, we need to let it go to the end because it's really unfair to do anything otherwise. Coming up, a pastor sues the Southern Baptist Convention for issuing a letter to the church regarding allegations of his sexual misconduct. The SBC argued that it had a First Amendment protection to do this. Let's see what our panelists have to say when we come back. When faith and government collide, the issues can be complex and consequential. Faith in Politics explores how religious conviction intersects with law, policy, and public life, offering depth, balance, and clarity with meaningful discussion and trusted insight. To see a bunch of our previous episodes, check us out at faithandpolitics.tv and subscribe to us on YouTube. There's an interesting case that's called Garner versus Southern Baptist Convention. The Southern Baptist Convention was founded in 1845, and it is the largest Protestant denomination in the United States. It includes nearly 47,000 independent churches with nearly 13 million members who voluntarily cooperate to share the Christian faith, provide advanced Christian training at Baptist seminaries, and demonstrate the love of Christ through ministries such as disaster relief efforts and services to at-risk children and families. And while each cooperating church is autonomous and governs itself, the SBC sets standards for friendly cooperation based on shared theological commitments. Those commitments include expectations for how churches respond to issues like abuse. Nia, the SBC has been involved in really a lot of these type of cases where they're trying to figure out how to ensure that their pastors are operating in a certain way. But when we see cases like this ending up in the court system, it seems to start to get a little bit murky when all of a sudden now I'd like a court to let me know, or is your religious activities in line with what we believe or not in line with what we believe, or should they be involved at all?
Yeah, so I think there are a couple of ways to think about this, right? Because ultimately what we see here is that the Southern Baptist Convention sent a letter to, I believe, either the church itself or the constituents to essentially say that, they wanted to find out if they knew that there was some level of sexual misconduct that was going on involving the pastor. And the pastor then responds by saying, hey, this is ruining my reputation. Now, the Southern Baptist Convention moved forward and says hey, but we have a First Amendment right to put forward these claims. Now, I do think that's one way to frame the issue. It kind of kills two birds with one stone in this current judicial climate, right? Where religious organizations are really taking it upon themselves to exercise their free speech rights and seeing how much protection the courts will give them, because it looks like the courts are very much so leaning into that perspective. On the other hand, it's very interesting that they're responding to a conversation really, which alludes to a tort claim of defamation here, right? Like that libel and slander suite of issues with a First Amendment response, when there are appropriate ways to respond to the tort claims of, the suite of tort claims under defamation. One of which I think begs the most interesting question here, which is whether it's true or not, right? Because the reason why this suite of claims exists is to protect constituents, right? And protect individuals from critical information that lets them know about, who is harmful and who is not harmful. And if it's true, then people have the right to share it. I also think that there's probably another social undertone that's happening here, which is that religious organizations don't want to be known as places that essentially protect abusers. This is something that many religious communities have been taken to task for, and not just in very high profile ways like the Catholic Church, but also, from scholars and researchers who have long said that the easiest places to engage in domestic abuse and sexual abuse is in churches. They don't do a ton of vetting. There's also a community expectation of grace, a community expectation of absolute forgiveness, no matter what. And so unfortunately, scholars have found that whether it has to do with domestic violence against women in partnerships, or whether we're talking about sexual abuse, churches have become the place to do this. And so religious organizations are trying to remedy this reputation, but that also becomes uncomfortable for the folks who may have thrived in that environment, right? Whether they're actually abusers or not. So I think there's a number of different forces here, but I think I would be remiss to say that the Southern Baptist Convention is not somewhat informed of the benefits of a free speech argument.
Orlin, it's interesting. I'm curious what the pastor, and I am sympathetic, particularly if this was just, a completely untrue claim and malicious claim.
Yeah.
Absolutely, I'm sympathetic to him. On the other hand, I'm curious what he thinks the Southern Baptist Convention should have done in the situation when they received this response. As Nia mentioned, we know that this is unfortunately an issue that occurs in religious spaces in churches, right? And so obviously, I'm assuming this gentleman has a pastoral heart. He cares very much about his congregation. It seems like, what did he feel like was the appropriate response of the Southern Baptist Convention?
Yeah.
To me, again, they didn't go public with this information. They went to the appropriate bodies, right? The church board or the church, governing organization, all of those things. Yeah, it's tough, but we know these issues exist. And we certainly know that churches receive warranted criticism when they don't investigate these claims.
Yep.
So I feel like they did the right thing here.
Well, I think, Melissa, there, the phrase you use, investigating the claims, is the heart of this. From reading the background of this, it seems like this is a process issue, not necessarily ill intent on anyone. So there was not an investigation, right? Southern Baptist Convention, just historically, especially the past decade, I think objectively has done a terrible job of this. They have not investigated claims of sexual assault. They have covered up some of those. I don't think that's too hard to say. That's been pretty explicit and legally shown. But the process by which they went about it was, well, the convention doesn't have authority, like denominational authority, over any of the local churches. So there was an anonymous complaint that went into the overarching national convention. They did not do an investigation. They don't have an independent counsel of this. They don't have professionals that do it. Instead, they called the senior pastor, where this other pastor who was accused was working, told him over the phone that there's been some accusations, you're going to get a letter soon. That senior pastor asked them 3, 4, 5 times over the last several months, like, this is a serious thing, tell me what's going on. And they said, well, we can't tell you, you're going to get a letter soon. And then the letter wasn't an explanation. It was just a questionnaire of, has this person engaged in any sexual assault, sexual conduct with children? What are they working on? Right. So all of this becomes not an accusation and not an investigation, not properly in any way we would say, but it is reasonable to assume for other people that something nefarious went on, but no one's actually trying to find the nefarious thing at all. This seems like an ad hoc issue from the convention to try to alleviate some of these issues for the past decade, but in a way that doesn't really make any sense that I think professional organizations would do.
Judge Hawkins, this sounds like one of your favorite kind of cases where you're asking the question, who dislikes who? Why are we here? And what's really going on when you really have no investigative powers, but you want to try to act like you do?
I would start my conversation by saying the most effective question you can ask in a jury trial particularly is, well, there are two. Are you lying now or were you lying then? And the other version is, so when was the last time you beat your wife? Because you really don't care what the answer is. You've just planted the question in the minds. And so they received, the Baptist Convention received anonymously a report that 12 years ago, the accused pastor had engaged in inappropriate sexual behavior in a previous location. Now, you've answered the question I had, Prof, as to why was the investigation sent over to the local church? Well, it was sent over to the local church because the convention couldn't do the investigation. And I say that's where the problem is right there. The investigation, who does the investigation, but their organization doesn't allow them to do so. Then I would say, failure to do investigation and take remedial steps means money, 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 hear the cash register ching. And then there was apparently no guidance given to the local church on how they were supposed to do this investigation, which now creates the problem. But the bottom line of this case is truth is an absolute defense. And before you bring a lawsuit like this, you need to be really clear that 12-year-old allegation that was made, which should come out as a part of discovery, is not true. Because if it comes out, I would dare say the church has definitely put up some type of boundary of protection around itself, and the plaintiffs, I don't know if I'd want to have sued for slander and defamation based on true allegations.
Well, Nia, you teach torts, so you kind of go down this road on a regular basis. When you see a case like this and you start thinking about the tort implications, it makes me wonder, where would somebody really want to be in the midst of this whole suite of activities? Or once you're in there, the quagmire is just so messy that something's going to stick on you anyway.
Well, I want to hinge on, some of the points that were made from my fellow panelists. And a lot of things about truth. right? So we have like the actual legal issues of like what is true and what is not true, right? Again, you have the Southern Baptist Convention who's tried to throw in, and also we have religious authority to talk about these things, hence our free speech rights, and like, again, capitalizing on the political moment, which is if they have like, really smart lawyers in their midst, this may be something that they do. But I also think that there is also a very meaningful social issue that is dovetailing with this, which is that unfortunately, churches have not taken it upon themselves to have really effective ways to solve for these issues, right? And so what we're seeing here, in my opinion, is a little bit of legal flailing, because at the end of the day, if you want to bring any of the suite of claims within a tortious defamation claim, the question is it true information, yes or no? And the fact that there is some question about what is true and what's not true, why is this being put out there, et cetera, it implies that something could be true, that, could be solved in the legal system. But again, these informal channels are designed to muddy some of this and also to protect certain groups' perceptions of congregational integrity, right? Like, this is one of the things that has always come up when we talk about sexual assault in churches. It's this idea that, like, well, if we really call this person to the front, if we really make them take accountability, it'll disrupt the entire, denomination or the congregation or what have you. But at the end of the day, the victim is the one who suffers, right? So I think that there's a bit of flailing happening here, where, unfortunately, we won't know until some of this works its way out in court. And as Judge Hawkins said in discovery.
Well, I got one other thing. You deny it until it's proven true. I think that it is a legally appropriate position for the alleged pastor to deny.
I'm going to let that be the last word, Judge Hawkins, because I think at the end of the day, inability to prove truth is where many people get off. But I do think that trying to get churches to understand the importance of putting together a process to properly deal with this that can withstand legal scrutiny is a critical part of where many of them need to go as well. Hey, Nia, tell me something I don't know.
So, did you know that Medicaid work requirements are only effectual in one way, which is to remove individuals from Medicaid rolls?
Didn't know that. Melissa, tell me something I don't know.
All right, Arlen, we've been talking about the Southern Baptist Convention. Did you know that, in fact, 23%, and this is according to Pew Research, 23% of Southern Baptist Convention members live outside of the United States South?
Didn't know that. Andrew, tell me something I don't know.
Orlin, I learned 2 new words today that I think help, and especially in our online debate format. One word is ultra-crepidarian. That's someone who voices opinions beyond their actual expertise and knowledge. And then my new favorite happens all the time online. Allodoxophobia is the fear of other people's opinions.
Judge Hawkins, tell me something I don't know.
Something's very basic. Did you know that one of the first patents in Louisiana was for Tabasco sauce?
Did not know that. Listen, great conversation today. Really enjoyed it. And thanks again for you being here with us. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.